One of them is Mr. Carlos Joani Ramos, who did post bond.
What?
Yes,
Where is he here?
he is. Right.
Come here. That way. That way. We don't want you near our DAs. When did he bond out?
When did you find out?
April 2nd.
You are on deferred with us for an attempted auto theft.
Right out of the gate, the judge's energy is at a 10. Notice how she immediately redirects him away from the DS area. A subtle sign she's already on high alert. When a judge starts a hearing this intensely, you know the rest is going to be wild.
You had an open possession of a controlled substance and you pick up 4 $30,000 to $150,000 theft cases. You are ordered to be under home confinement. I don't want you out at all.
This is a major legal moment. The judge is basically warning him that any violation of bond conditions could slam him back into custody. Judges rarely say, "I will light you up," unless they feel the defendant is a genuine risk to public safety. Dramatic and serious.
I want my public safe, and I'm going to do everything in my power to protect it. If I find that you pick up another case, if I find that you break any of these conditions, I will light you up. Do you understand?
Sir.
I'm sending him now for a drug test. I want to know what, if anything, is in his system. And then I want him back. Okay? GPS monitor, home confinement. Do you know what the felony court did?
Yes, Your Honor, I believe on the last setting, you mimicked the same conditions as those. That includes the GPS monitor. That's a risk.
Pero a mí me pusieron que puedo ir a la escuela.
With the exception of going to school, Your Honor.
No, I don't care. I don't trust you to be able to go to school with 1, 2, 3, 4, 5, 6.
Here's the emotional core. The judge isn't just angry. She's scared. That's important. In courtroom dynamics, when a judge openly says you scare me, it signals a real concern about future crimes. And with 6 open cases, yeah, the stakes are sky high.
Cases, 5 felonies that are open. The only thing I want in this life is my county to be safe. And you out there in the free world truly scares me, because I don't know what you're doing, and I don't know if you truly want to do schooling, it can be done online. I don't want you out. Do you understand me? I'm sending you now for a drug test, and I hope that you're not using. On your other ankle, I will put a scram monitor so I know that you're not consuming alcohol. I will bring you here periodically for drug testing, and if I find that you're using, your bond right now is set at $10,004. If I find that you're using, if I find that you go out, and I'm telling you now, I don't give a rat's behind what it's for. If I find that you're out, I'm going to make your bond so high you'll have hair falling out. Do you understand? I want to send him for a drug test now, and then he's to come back, and then we'll go from there.
Just so you know, with felonies, they do have them on a curfew. With the curfew, he must be inside the house by 1:35 p.m. and he is not allowed out until 7:25 a.m. He got a small window during the day where he's permitted to be out.
For what?
That's what.
Where? To where?
It says for school.
The defense finally steps in here with a classic move, highlighting presumption of innocence and pointing to family support. This is strategic. Judges love structure. But notice the judge's reaction? She doesn't buy it without proof. This back and forth is courtroom chess.
Where's the school?
Evolution Academy.
I don't know if I trust him enough to be able to do this. You know,
Your Honor, I will say,
they're open, and then he has an auto theft with us.
I understand. I just feel it's going to conflict with what they have in the system.
Yeah, I know it's going to come.
Yeah.
I know. I just don't care. You know, the only thing I care about is my county being safe. And with 6, and at that young age, you know, it just,
Regarding the new felonies, Your Honor, I do want to remind the court that there is a presumption of innocence, and that's what he's currently doing, working on that. And it seems like his mom is the one taking him to school, so he does have someone, a support system to make sure that he's,
I don't know that. I mean, if you bring
and I've
mom
spoken to his
here,
mom.
I mean, you get mom here to show me that she's going to do that, you know, then perhaps. But at this point, Mr. Ramos, you scare me, truly. And the only thing I want is you not to pick up a seventh case or someone to end up dead or another car to be gone. Do you understand? But at this point, and I don't know how someone posted up $100,000 bond on you, but if I remember, the bonds were all set at like what, 50,000, all of them, and then the felonies all got reduced or something like that.
I think they're 20.
I don't know what the felonies were at. It looks like they're all $20,000 now.
Yeah. All I want is my county to be safe. That's all I care about. If your mom comes here and tells me that she's going to take you,
She come right now.
Is she here?
Yeah,
she's here right now,
she's downstairs.
go get her. Go, let me talk to her.
Okay, sounds good.
Do you need a translator?
Does she speak Spanish only?
Yeah.
Yes, Your Honor.
Can you call a translator, please? Thank you.
This feels so, recommending white man.
For him? Hell yeah. Hell yeah.
You can go to the bill today.
Problem is, if we can't, with the felonies open. But it's money. It's money.
I have.
So did you hear what the recommendation is?
No, I didn't.
WIMAC.
What was it?
WIMAC.
I'll change.
I think it's money. You know, that's with the other gentleman that was just here, he was in WIMAC and he's doing great, you know? But the problem is that we can't while this case is upstairs, so we're kind of in holding pattern. But when does this expire?
It's the addendum, so if they got some to another year. You want a date, to give you a date?
I just don't want it to accidentally expire because these cases are probably going to go on for the next year.
Set to expire November of this year.
Okay. I guess we'll address it getting closer to. But that's for me, that's the goal. That'd be great.
Okay.
Yeah. Okay. Right. So let's wait for mom and then we can.
Right, Judge, for Ramos, you said Scram?
Yeah. Scram and GPS. And can we have someone that actively, if he goes to school, can they put,
Let me look at the next judge.
I'd like to know if he's deviating from school, right? If he's going somewhere else. So there's got to be a way to get there and a way back from home. So we know they're going directly to school and directly back. So they're
The
not,
same way we're covering his home zone, we could cover the school as an inclusion.
yeah.
That'll be fine.
So we know through that 4-hour window, he's at that school and doesn't go anywhere else. And if he goes somewhere else,
New defendant, new chaos. This time it's drug testing. THC battles in court are messy, even with a prescription. Legally, judges can order you not to use, even if you're allowed medically. And he's been presumptive positive multiple times. Buckle up.
boom, it dings and we know.
I think
And then
that'll work best for the device as long as that's very background too.
Yeah.
Let me include that on your conditions then, that the school and this location.
Well, I want to talk to mom first just to make sure that she's going to do it so that she's taking him to and from school, because I'm not going to accept that he's taking one of his friends or something like that, you know? You ready, Mike?
Yes, Your Honor. Have Mr. Andrews on docket?
Okay. Did he get tested today?
Yes, Your Honor.
Andrews.
Yes, presumptive positive again for THC around. And 3 weeks ago, he tested, it was presumptive positive THC, and then it was lab confirmed THC.
Come up, sir. What am I supposed to do?
I have no idea, sir.
Either you're continuing to use or you just don't care about court orders. I've ordered you not to use. We're now working. When did we order him not to use? What was the day?
I've been on this case that long.
His case has been open since February.
The
end of February.
February 26th, Your Honor.
Say it again?
February 26th.
Yeah, February 26th. We're now April 16th. It's been 51 days.
Oh, you did.
Yeah.
I'm putting you in jail. I told you not to use. You're continuing to use.
May.
Okay?
And I know how the court generally feels about the prescriptions for the marijuana, but he does have a valid prescription.
Nevertheless, I told him not to use.
He's gainfully employed judge, which when we came here previously, you had ordered him to get a job, which he did. And of course, he's brand new at the job. And if he goes into custody, he's most certain to lose that job.
Michael, I don't want him to use. What else am I supposed to do? I don't care that you're now working your second criminal case within the last year, you know? Give an assault from 23, now you've got a theft.
One more opportunity, Judge.
How long am I supposed to give him, Malcolm? Another 30 days for him to just continue smoking weed and just...
Test them in 2 weeks, Judge? Or even, I don't know if next Thursday will be too soon for the levels to go down. I'm not really.
Do you have levels now?
No, none of this time. This is a rapid test that needs to be confirmed in the lab, so.
If you want me to give you the benefit of the doubt of next Thursday, I will do it. You must be here Thursday. If you test positive for weed, it's not going to go well for you. I've harped on it over and over and over.
Yes, sir.
Judge, and I don't know the science, is what currently in his system, would it be gone by next Thursday? Or would it still be in his system and he tests
If he
positive?
continues to smoke, then no. But by then it'll be 2.5 months. So if it's still in his system, that tells me that he's continued to smoke weed while he's on bond. You know,
Yeah.
there's only two things. It's either in your system or it's out of your system.
I don't smoke, so I got THC tinctures.
What's
I
that?
don't smoke flower. It's not a flower.
You're not supposed to use anything that has THC in it that could cause you to test positive. You know exactly what you're putting into your body. You know exactly what I've ordered you not to do. We'll put you on for this Thursday. I don't know what else to tell you. I mean, you want hieroglyphics? Perhaps Mandarin? I don't know what else. I'm speaking English here. I've told you what you can and can't do. That's it. I'm going to give you the benefit because of Michael that you got until next Thursday. If you continue to test positive, it's just not going to go well. All right?
Yes,
See you
sir.
Thursday.
Thank you, Judge.
All right.
Now we shift to a completely different case. Criminal mischief, a scratch vehicle, and a kitchen knife. The judge's tone here is fierce. Notice how she immediately drops a no-contact order. This is textbook protective order energy, and she makes it very clear she'll jail her if she violates anything.
Good morning, Miss Gordon. Ma'am, you are charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Thank you, Your Honor. On April 8, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an apartment complex and made contact with a complaining witness who stated that she and the defendant were in a previous dating relationship and currently live together. They'd gotten in a verbal argument and the defendant locked the complaining witness out of the apartment and eventually let her back in. And when she re-entered the apartment, the complaining witness saw the defendant had soaked her clothes in bleach. The complaining witness then told the defendant to leave the apartment. The defendant then left the apartment and took a large kitchen knife outside. And the complaining witness then witnessed the defendant scratch her vehicle with the knife, and the defendant scratched the word bitch onto the hood of complaining witness's vehicle. The complaining witness estimated that the total Damages to the vehicle were approximately $1,000.
Ms. Gordon, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
The last part again.
I'm ordering you not to have any contact with this person, not to be in possession of any weapons. If I find that you do, I'm going to put you in jail. Do you understand? I will make your bond high. I'm going to protect every person in this county. I don't care who you are. I don't care if you're a small farm animal. Anything you do to endanger my community, I will revoke your bond and put you in jail, and I'm going to make it high. If you don't have anyone to pony up $5,000 to $10,000, you'll be stuck like Chuck in there until this case is over with. Do you understand? Do you mind reaching out to this person to let them know that we've put these conditions